But as the government is proceeding with legislation, we are calling for protection of conscience and religious freedom, for the strictest possible safeguards in order to minimize harm and risk to vulnerable persons, and to ensure occurrences are rare, and to protect our society's commitment to the respect for life. So on the matter of freedom of conscience and religion, the minister, when she appeared on Monday, said that this legislation does not compel medical professionals to participate in MAID. While that is technically correct, the minister also said that MAID is now considered, quote, medically necessary treatment, unquote. This places conscientious objecting persons and institutions at risk of coercion. Actually, looking at it today, someone pointed it to me, Section 227(4) creates an exemption to Section 14, which appears to at least delete the caveat of no one is entitled to. That seems to create an entitlement for. Our concern is that creating a right establishes a corresponding obligation. If you accept the premises that medical aid in dying is a right, you have an obligation to protect, we submit, the freedoms and rights of doctors and other medical professionals. The College of Physicians and Surgeons of Ontario, as you've heard, has already decided that all doctors must make effective referrals regardless of conscientious objection. What will this government do to protect medical professionals from being coerced to participate in the killing of another? Even in times of war, conscientious objectors were exempted. Medical practitioners must have the right to refuse to participate in a physician's hastened death, either directly or indirectly, for reasons of conscience or deeply held beliefs, including the right not to make a referral. Also, there's been no commitment made to exempt objecting institutions, protecting their staff and the communities that provide care, which we feel is equally important. We recommend that protections be included by express statements in the preamble of the bill. We also strongly recommend that conscience protection be included in legislation as a standalone provision in Bill C14 or as an amendment to the Canada Health Act, or by creating a criminal code offence that prohibits coercion of patients, medical care providers, and institutions in relation to medical-assisted dying. Did you know that the Banking Act forbids a bank from coercing someone to obtain a product or service as a condition of receiving another service, or that it is an offence to coerce someone either to belong or to refuse to belong to an artistic group? We are talking about hastening death of another in this context. How much more important is it to protect the conscience of medical professionals and institutions?
There was a comment, I believe it was Mr. Clemenger, that made a comment of the importance of conscience protection. C14, we've heard from the minister, does not compel or require a physician, medical practitioner, nurse practitioner, pharmacist to be participating in assisted suicide against their will. So they're not compelled. Yet there is hints that it would be the College of Physicians and Surgeons within each province that would determine whether a person is required to have an effective referral or not, which some physicians would find objectionable. So there is problems in the regime that's being proposed, but I want to focus on conscience protection. Canadian Medical Association said 70% of physicians in Canada do not want to participate or refer. 30%, 23,000, represented by 30%, would be adequate to provide access. So why do you believe there's a push that the 70% are not protected? Not compelled or required, but they're not protected. Why is it so important to have conscience protection included in C14, or should C14 be amended at a future date? Your comments.
We believe that it needs to be amended now before it is passed to make clear protection for conscience of both doctors, medical personnel, but also institutions that provide extended care, on which premises someone may request assisted death should the law pass. Again, as I said in my comments, the minister did clarify that nothing in the bill says a doctor will be obliged to. However, you look at the whereas statements, and it's clear that they're creating a regime around Bill 14 that will deem medically assisted death as medically necessary. And once you create that paradigm, then the question is there an obligation? You're in a sense taking what I don't think Carter established a right to access. It was an exemption from the application of criminal code. But if you begin interpreting and framing it as a right to access, then there's an obligation to provide. And I guess the clear example would be the College of Physicians and Surgeons of Ontario, which already require an effective referral under the current regime while the bill's being suspended for the next 4 months. So we think it needs to be placed. We think there needs to be a statement in the whereas section clarifying that no one will be compelled, contrary to their conscience or beliefs, to participate. We think there could be a parallel, you've heard this before, there could be a parallel paragraph inserted in Bill 14 along the lines of the 3.1 in the Marriage Act to protect it. But also there's been some proposals I know that have been submitted to this committee that actually clarify and define actually criminal code provisions against coercion.
To Mr. Clemenger, I'm not sure if I understood this, but when you talked about the conscience protection, have you looked at the legality, the constitutionality of us putting that in federal laws? We've been struggling to address your concern, but many of us, including the leading practitioner in the province of Quebec, says it's clearly and utterly provincial jurisdiction, and even if we wanted to, we couldn't do it in federal law. Have you got an opinion on that point? Yeah,
we've talked to a number of constitutional lawyers ourselves, and they believe it is possible. Again, it would be coercion. As I gave a couple of, kind of simple examples, but again, the idea would be we'd make it a criminal offense to coerce someone to undertake a certain action was deeply contrary to their moral religious beliefs. So it's a reaffirmation of the freedom of Section 2A.
In the bill requiring a doctor to provide this service.
But as I said, it's the context of the bill, it's what the Justice Minister and the Health Minister have said in terms of making it a medically essential service. We already have the example of the Ontario College of Physicians and Surgeons, which are requiring
the essential service in the bill. I don't know where that
exists. She said it in
no, but we're talking about the law. Is there anything in the bill that you can point to?
I guess the only I was referring to the whereases and then the broader context of what the regime the government's planning to set up in the context of C14, and that's what gives us concern. But also we have a live example of the College of Physicians and Surgeons in Ontario, which are right now requiring effective referral, which is deeply contrary to the religious conscience and beliefs of many doctors. So they need protection.